Hello, dear viewers. Welcome back in the Indus Lex. And in this session, we are going to discuss how to protect yourself from jail. It is relating to the criminal procedure that if a person has committed a particular offense and if that offense is not bailable, then police may arrest him. When police may arrest any person, when police found that there is a commission of cognizable offense, then he may arrest an accused without an warrant of the court. So basically, when an FIR is lodged against you, you have to be alert. Not only to protect yourself, protect your personal liberty, but always remember the prosecution is a criminal case. Facing prosecution in a criminal case is a trauma, and if that case is lodged with ulterior motive, malicious intention, then facing that prosecution is very much dangerous for your liberty, and also it's malign your reputation in the society. So dear friend, whenever an FIR is registered against you, maybe rightly or wrongly, you have several remedy. Criminal law comes in motion from the registration of FIR, that is the first information report. When police write a first information report on the information received which discloses the commission of cognizable offense against a particular person, then criminal law starts, it's come into the motion, and after registration of the FIR, police starts its investigation. Now police will see whether the commission of offences which is alleged to be happened is punishable by what terms of imprisonment. If the commission of offence shows that XYZ section must be invoked, and that section is punishable by less than 7 years of imprisonment, or maximum 7 years of imprisonment is provided in the statute, then always remember that the police is not going to arrest you directly. Instead of this, police will give you a notice. In the previous laws, it says the notice of under section 41A CRPC. Now the new section in Bharatiya Nagrik Suraksha Sanhita 2023, that is section 35(3), that the police will give you the notice that look, your name is appeared in this case, and you have to be appear before me at a particular place on a particular date, that is the particular police station on a particular date. And if you comply with this order, then the police will not arrest you. But if you fail to comply the direction given under section 35(3) notice, then police may have power to arrest you without an warrant of the court, on the ground that you have not appeared before him. But it may be possible that you may appear before him, but police officers illegally detained you for a days, and on the another day they show you that you have not complied with the notice, and they got arrested. So whenever an FIR is lodged, be very wise and try to challenge that FIR initially. Directly hit on the root of the FIR, having your defense that it may be due to make pressure on you on the civil dispute, or maybe there is a commercial transaction which given color of criminal case, and so you have to challenge that FIR at the initial stage. Honorable court, look, the allegation surfaced in the first information report, and in accordance with the judgment of Honorable Supreme Court in Bhajan Lal and others versus state of Haryana, they try to find out whether your case can be quashed or not. And if the court finds that there is some material which have to be seen, then they will stay on on the criminal proceeding arising out of that FIR. So, if the first information report is lodged under the section 40, under those sections which are punishable up to the maximum imprisonment of 7 years, even though you have to challenge that FIR, and if the section invoked by the investigating officer having the punishment more than 7 years of imprisonment, including life imprisonment or death penalty, then you must challenge that FIR. Suppose that if you challenge that FIR which has section punishable less than 7 years of imprisonment, even though the court will not grant you the stay on the proceeding, if your case is come in the ambit of Bhajan Lal case, that is, you can able to show that this is a prima facie a malicious prosecution against you, then you may got relief. And even though if you not get relief, at least court will order that without the warrant of the court you will not get arrested by the police officer. And if the punishment is above the 7 years of imprisonment, you may also approach the Honorable High Court under Article 226 challenging the first information report which lodged against you under particular section. At that time again the same principle will be applied which is enunciated in the Bhajan Lal case, and the court will see whether your FIR is lodged with the ulterior motive, or it is abuse of process of law, or there is no offense is made out, or in certain cases there is cognizance is barred by the statute itself, because there are several special statute in which police cannot take cognizance of the offense and it must be filed by way of complaint before the competent court. So you have to consult your advocate and talk about the what relief or what remedy you have. But whenever the first information report is lodged, whether it is rightly lodged or wrongly lodged, it doesn't matter. You have to challenge this before the Honorable High Court under Article 226. You have to be more cautious when the punishment prescribed in the statute in the particular section which is invoked by the investigating officer is above 7 years of imprisonment. Then you have to protect yourself, hide yourself from the investigating officer, because whenever investigating officer faces you, he will try to arrest you, because he has no power to leave you when offense is of such a serious nature which has punishment prescribed under the statute is more than 10 years. Apart from this extraordinary jurisdiction, we are talking about the Article 226, the Constitution of India. You have another remedy and several other remedy in the statutes